school.
A doctor.
Doctor, yeah. Probably a successful one.
Good morning. Good morning, welcome. We have 20 minutes, and you have 3 minutes to the opening and 2 minutes to close, so begin whenever you're ready.
Well, thank you very much. Very nice to see you all. Appreciate your taking the time to meet with me today. I guess I would start out by saying a couple of things about myself that may or may not be summed up in my application. My practice has evolved over the years, as you know, from reading it as a federal practitioner and now more of a state practitioner. And in fact, I was telling one of the other applicants that my first appellate appearance was in the old Fifth Circuit when it was in New Orleans, right at downtown next to the U.S. Attorney's office there. So it was quite impressive. And then over the years, I've appeared in the 11th Circuit in the federal system on many, many occasions. And then here, I just filed a brief in this court maybe 2 weeks ago on the stand your ground law and some of the legislative changes to it. So it's been an interesting perspective, I guess I could say, where I started and where I am now. And I really enjoyed it. I think that that's one of my strengths in my application for this position, is that I do have a very diverse background in practice. And I realize that I haven't been a judge, and that is always a question. Well, what kind of philosophy do you have? Because we can't read your opinions or your orders. And I have, I like the answer that Justice, when he was talking about being an umpire. You know, you're not batting and you're not pitching. You're there to umpire and call the shots. You're not there to write law. You're there to interpret law. And that is my philosophy, my judicial philosophy, and that's what I would bring to this. But not having been a judge, I do realize that there's an argument to be made, well, you need to have that experience before we would bring you on an appellate position. And I do think that there's a case to be made, an argument to be made, that, you know, if you have a more diverse background, you bring something different to the table and to the mix. If you have all judges that all have the same background, maybe they're going to be a little, make the same approach. And having a different background, maybe you bring something to the table. And I think that I've developed a lot of judgment because of the diverse background that I've had that might be a little different and helpful in sitting on cases. Rick?
Yeah, well, I had the honor of vetting your application, and I obviously know you from my time working with Judge Sharp, and I know you're a fantastic trial lawyer. I'm glad that you applied this time. And congratulations on making the short list for the open circuit judge spot. So I'd like to give you an opportunity to address between getting an appointment to the circuit judge versus getting an appointment to this court. Which would you prefer and why?
I would prefer this one. I think that I really am more, in some ways, more qualified for this. And that may seem to be a little, because I haven't been a circuit judge, that may not seem to be the obvious answer. But I've spent more time in the last several years writing appeals on the Criminal Justice Act, as a Criminal Justice Act lawyer and a privately retained lawyer in the federal system, and also in the state system as a retained lawyer. And I love trial work, and I think I would be fine and be a good circuit judge, but I really like the appellate review process a little bit more, and I think that's something that's developed with age and with experience, and I've gotten more interested in that aspect of practice of law. So I would prefer this appointment.
There have been a series of recent opinions that come out of the appellate courts effectively using access to the court's arguments and court amendment arguments, process arguments, to invalidate acts of the legislature which have historically limited remedies for plaintiffs. What's your position on those doctrines that have, and the counter position you see between the legislature and the court system?
Well, I do think that, and I bring up, I just kind of looked at this issue in the Stand Your Ground case, where because there's case law in this circuit that talks about what brandishing a weapon and whether or not that's deadly force. That's the specific issue I'm talking about, and that your question is broader than that. But the legislature just made changes to the statute in the last session, and if that's a correct statement of law in the circuit, then the legislative changes don't mean anything. And of course, there's a lot of law that says, you know, they have to mean something if they're a clarification. And so I'm interested in seeing how that plays out in the case that I have. Like I said, I just filed a brief 2 weeks ago on how that's pending in this court. And that doesn't involve the Fourth Amendment situation that you're talking about. But I do think there's a tension there, and it's going to be interesting to see whether or not the courts will re-examine some of their precedent, or whether or not they will give effect to the legislative changes, or how that creative tension is resolved. But I do think that some of that, the recent case law, or some of the litigation is a little, it's stretching it a little, in my opinion.
Have you had your interview yet with the governor? Is it scheduled?
No.
Could you speak to what you could bring for the civil side of this court?
Yes, and I recognize that my background's more criminal. On the civil side, I did spend a year in the U.S. Attorney's Office doing civil litigation and defending the United States, specifically in medical malpractice actions, a lot of other things that the federal government gets involved with, immigration and that sort of thing. We had also some where we sued, some proactive kind of litigation, and I think I pointed out in my brief that I did an arbitration on that. We've actually got a judge from the Board of Contract Appeals to be our mediator, and we settled it for $3 million, which went to the United States Air Force, which was our client. So I do have some background in that. I think a lot of the trial, conducting a trial, and some of the standards are going to be the same. I recognize that there will be substantive matters and substantive areas that I would have to, I can't know all of them. Even in the criminal side, I don't know every substantive area. I know a lot, but I can't say that I know all of it. So there will be some learning that would have to take place in each type of, probably in every case that you have coming in front of you. But from that perspective, my orientation, I guess, would be first, that the lawyers would educate you. I think you have to rely a lot on that. And again, I guess I come back to my philosophy, which is essentially one of interpreting, not creating. So that would be how I would look at the cases that would come before me.
Can you talk about your pro bono work, being a guardian ad litem, and how that has impacted your practice and possibly your decision to seek judicial office? It's been actually,
I'm glad you asked that, because it has been very instrumental. I always wanted to be involved as a guardian ad litem, but I couldn't do that as an assistant U.S. attorney. So that's one of the first things I did when I went out into private practice. And interestingly enough, yesterday we had a trial, and I was the guardian ad litem when I testified for the manifest best interest of the child. And on a case that had been going on for years, way too long. But there were a lot of reasons for it. The father had gotten arrested again and delayed everything for another year and a half. It was 6 years this child was in foster home. and the parental rights were terminated in this particular case. But having 6 years in that system in one case, and I've done several other cases, many other cases at the same time, but this was the only one that was consistent. That was a system I really was unfamiliar with. And there are a lot of things right about the system. And I think the guardian ad litem program in Orange County, which requires you to be a lawyer, is vastly preferable than, let's say, Seminole, where it's not required. But that is also an area where I see there's a lot of room for improvement. So it's interesting to me to get involved in all of the child welfare litigation from the practitioner, from the guardian ad litem point of view, as opposed to the appellate point of view. But it would still be a part of the practice, and I was just amazed at that there are a lot of really dedicated people in there, but there's a lot of turnover too. So it really did. It was probably the first experience, the fastest, quickest state experience that I got when I first went in the state system.
Was it TPR?
Yes, for both parents, but the mother had long gone, and the father was sort of there, but not quite making it for a number of years. So it's a difficult decision, but as I say, I did testify that his rights in that particular case should be terminated.
Yeah.
I noticed on your financial history that 2013 was particularly good. You about doubled your salary from 2012. What do you attribute that to?
I did more criminal trial work in the state side. I had a couple of big cases that I tried. I really like private practice. I've had a lot of success from it. I've been able to pick and choose. On the federal side, I represent some doctors and some Medicare. I do a lot of white-collar fraud type cases, business people. And the only way you do any good at all in that is to keep them out of court from ever getting charged. So you have to do your own investigation and have a lot of interaction with investigative agencies in the prosecutor's office. But I tried a couple of more state trial work in that year. But it's nice because I really have enjoyed it. I do get to be selective to do the kinds of cases that I want to do, and in cases that I think I can really make a difference and not just take somebody's money. But in business, defending fraud cases particularly, I've had a lot of cases that just never got charged, and that's I think one of my best results. But it's not anywhere published. Thank God, because you don't want the client's name out there. But I think that's fine. So I've been really happy with the defense work, and I've done as much as I wanted to do, let's put it that way, and feel successful at it. But I really think a judgeship is where I need to be, and I think I would be very happy with it and good at it.
Yeah, along those lines, can you give us a sense as to the volume of your practice? How many files are you handling? What kind of staff do you have there? That kind of thing.
Yeah, well, a lot of that I'll add is, for instance, with the doctors in the Medicare fraud case that I'm thinking of, I hire, bring in extra investigator, extra staff, because you can't, it depends on where you are in it too. You may not need that for the whole time. So I'm pretty selective in the cases that I do. I don't do walk in, some guy hit his wife, a Saturday night thing. I don't have that kind of practice at all. It's more like white collar defense practice, some forfeiture work, a lot of appeals lately. That's I've sort of gravitated a little bit more to the appellate side than I have in the last few years. But I would say that I may have 20 files going on. Some of them very big, and if I'm in trial, which I was I had a child molestation case, which was particularly difficult to handle from the defense side, and of accusations that occurred 20 years ago. So in that case, I had to bring in extra investigators to look at, and I'd do that more on a contract basis rather than employing somebody like that full time, because I wanted somebody specific. And in that case, somebody that I actually knew from when I was prosecuting, that I had a lot of confidence in, that could go back and dig. And so, But if I was doing a criminal tax, I would get a former IRS agent that I know to come in and do those reviews, financial type cases. So I use different people as I go, but I'm pretty selective about it.
So I get the sense you, again, sort of, like you said, you're selective, you pick
Yes.
which cases you want, it's interesting, I like it, that type of
Yes.
stuff. Realize that you come over here, that's not gonna be your world.
Yes, I do.
Okay, so
I
tell
do.
me how you're gonna reconcile that in your own mind in terms of, because you said you really enjoy that. This is gonna be, you get what you get and you do it quickly.
Yes.
So tell us how, make us feel more comfortable.
Yes.
That you'd be able to assimilate into that.
But I've
pretty
done that
easily.
before. I mean, I've been there before. As a federal prosecutor, I not only handled full-time trial work, I tried cases that were 3 and 4 months long, and I didn't use other lawyers because I don't like to do that. I like to do it myself. So I would be handling anything that came in the door, trying the case and still carrying my full caseload. I think I'm kind of looking for that change. That's kind of what I'm looking to do, is to diversify and broaden my practice a little, and to handle more things like that. I enjoyed that. And when I was able to do that in the federal system, I really liked it, because I did everything from, trademark infringement, fraud, to, bank robberies. And that's so intellectually stimulating. I totally enjoy that. And as a criminal defense lawyer, I do like to do different types of cases in both systems, because it is completely different in the state system, and that's exactly right. Just sitting in the circuit court for a day, you can see what all comes through the door, and it's bam, bam. You have to be able to move fast, but I'm able to do that. I would enjoy that. I'm looking, I think, to pick up the pace a little bit.
Okay.
You have 2 minutes to close.
Well, if there are no other questions that I can answer, I would just hope that I've answered all your questions, either by my responses or in my application, and just say that I welcome the opportunity. I think I would be a good selection for this, and I would very much appreciate it if you give that serious consideration. I know you have, and it was very pleasant to see you again today.
Thank you.
Thank you.